The conversation went something like that. How much is it pay? This is $800. How much is it pay? He said, you know, this is a, these are charitable donations. Okay, how much is it pay? Pretty much. And maybe I'll go through it. Okay.
Victor said he's on his way.
Oh, okay, that sounds good.
I know. Yeah. Just tell it, just tell it like this. Okay.
Hey, Daniel?
Okay.
Daniel?
Okay.
I think you're probably not gonna need.
You're
paying. Daniel? Who's made sure, because everything, oh, look at the I'll show you what that is, this is one we,
I just kind of grabbed it, but I didn't know.
And Brian, we graduation with my grade was naked, and he was never from the show. He lost the picture. Yeah.
Do you know the Wi-Fi password?
Not for the professors.
They
But,
probably do.
yeah, but for the students, it's CDTA 2016 $sign.
Okay.
Thanks.
That's funny. My passwords have $signs too.
And I think it's all lowercase too.
Okay.
Yeah, I don't know the professor one though.
Yeah, that's all right. I'll see if it works. My kids always ask me where we went. Do you know the Wi-Fi password? I'm like, that is the most annoying question ever. Now I have to say it out loud. They just wanted me to email them something like that. They're gonna make me ask, I think. Yeah, it worked. It took a while, but it connected.
Did it work?
Yeah, thank you.
Oh.
That's awesome. Wow, the power of knowing the Wi-Fi. I can do anything now. Oh, my goodness.
all the story. Yeah, if you could have like a story of each one. The only one I'm here.
At least it's a short chapter tonight.
I know. Although, you know, I always have to pick something apart. Besides the island of minutia, I feel like that one, it's like, this is a special community property rule regarding the personal injury.
Yeah.
The special rule is it's separate property.
That's what I thought, and then I was reading it, and they made it.
Right, and then they can switch. It was terribly wrong, right?
Yeah, it seemed like they made it a lot more
Complicated.
complex than it needed to be.
Exactly. And then I felt like it kept going backwards and forwards. Like, it's community property. It's community property. And they're like, but it's going to be awarded to the one who's injured. So, yeah, unless it's terribly commingled.
Yeah.
We don't want to do the math.
Oh yeah, all of a sudden there was $1 million deposited into this account. I don't know where it came from.
I don't know where it came from. Or if, like, circumstances warrant it. Okay, that's anything, right? It's whatever the judge thinks.
Exactly.
Yeah, I thought that was interesting. But the case was really interesting. I liked the case, reading it.
I felt bad for her.
You know why I didn't feel bad for her? And this is not fair, because if I was a juror, they would have kicked me off the jury. But the day before I read the case, I saw that movie Upside about it. It's a new one with Kevin Hart, and it's a comedy, but it's sad too. He's the caregiver of a quadriplegic. Mm-hmm. So I saw that the night before.
And you're like, no, he gets his house.
He gets everything. He gets everything. It was totally unfair bias, like walking into it. Because in the movie, you see how they have to feed him. Yeah. He can't even get like something out of his tooth. You know, like when you eat broccoli, you can't even get broccoli out of his teeth. And I was like, oh.
I look at it, she had to quit her job.
Right.
And then now she gets nothing. Like nothing. If she was just a deadbeat spouse sitting on the couch and they got divorced, she'd get half of everything. But because he's injured, she doesn't get shit. And it just seems unfair.
Right. So she's like, she gave up her career and she gave up all her rights to community property. So she's gonna be homeless.
Exactly. No, she's in a better position to restart. Okay, but she's not.
I know. I feel what the judge was thinking is she's probably gonna remarry, but they can't say that.
Yeah.
But yeah. No, I wish you got to see that movie now. It was a good movie. I'm sorry. I forgot.
No,
I forgot what it was to be in law school.
I know. I just got like, as nerdy as this is, I just got a new video game and I haven't been able to play it like all week. And I'm like, I'm waiting 13 years for this installment to come out. And I've had it for a week.
I know. What are you
and I can't
thinking?
do
Like
anything.
spring break.
Well, no, I mean, I will just.
Bear down and play it.
Yeah, I will. I mean, I have Sunday.
I know. And so, like, next week, I think it's 68 pages. The week after, there's a ton of cases. And there's like 6 cases, but they must be short because I think it's 75 pages or something. But Professor Mack will be here.
Oh.
So you'll.
For next week?
Not
week
Valentine's.
after.
Yeah, the week after Valentine's Day. Yeah, just because I have
The DBA.
the DBA meeting I have, well, you know, that I have to go to. Oh my gosh. But, oh my gosh. Have you ever had a class with Professor Mack?
No, well, we've had MCLEs.
Okay, so he's lively. Okay,
Yeah.
you know, that's all I needed to tell you.
Yeah, I know, we've had him for MCLEs before.
Mm-hmm.
I don't know where Victor is. He doesn't live that far away.
I know. I'm like, this might be one of those classes we actually leave when we're supposed to, or closer than we're supposed to. I told AJ Dolan, I'm like, we just went through the material. Like, they get it. It's not hard. It's not. I can't give you 200 pages of reading. That's not right in other classes. And she's like, just do hypos. I'm like, 2 hours of hypos.
Yeah, I mean.
Get ready for that.
They don't even, like, elementary does it, but in real property, we'd be done at like 7:30 anyway.
It's the
There you
same
go.
thing. Yeah, it's the same thing. Property is property.
Yeah.
Like, there's not much you can debate about. It's not criminal law where people are crying over
Yeah,
it.
no. But even in criminal law, we'd be done by like 8:30. And
Yeah.
All right, go.
Right.
Nobody wants to be here longer than they have to be, especially this late at night.
No, exactly. Especially if you get it. If you're struggling, then.
Well, yeah.
you know,
Like if I don't get it, I will sit here until I do, but
Exactly.
or until I'm completely fed up and I won't get it.
That was me today. I'm like, I'm done. At work. Like, yeah, it's good to know when you just need to walk away from it.
Yeah.
Hey, so.
Hey, don't worry about it.
Nope.
Oh.
We're just getting caught up. So, how's your day today? Anything exciting?
Just super busy. It's one of those days, but they don't come to often.
Yes, I know. At my work today, I was helping one guy with his child support. He pulls out another case. I'm like, okay, 2 child support cases, a third one, and then a 4th one. I'm like,
How many more do you have?
I know. I'm like, all right. Is there anything else you want to tell me? 4 separate child support cases, and he's just like pulling one out after I think I'm done.
You can't just fill one out and be like, okay, you know how to do it for the other 4?
Copy and paste.
Basically, I mean, I can't imagine that the information changes.
No,
other
not
than
much.
date of birth and stuff like that. But
names and amounts. That's it. Names and amounts. But oh my gosh. Well, one day you guys will have to come and observe at the courthouse.
is it only you in there, or do you with the staff?
I have 2 clerks, but they're pretty much preoccupied with restraining orders because we get slammed with restraining orders too. And then a paralegal, and then me. So it's just the 4 of us. And some days it's just out of control. Other days it's quiet.
Mm-hmm.
And then today wasn't bad. It was just people
People
are
suck.
driving me nuts. Yeah, people suck. Oh my goodness, so I'm glad you guys are here. So luckily our lesson wasn't that long for today, so that's good. I also thought maybe you guys would want to do your own divorce petition, so you don't have to do it.
Just to be ready.
Were you
It'd
so
be really
excited?
easy. Everything for me is a 0, and I don't know jack shit. But take half of nothing. It's still nothing if I did math right in high school.
Okay, fully disclosed.
Yeah, fully disclosed. I got nothing. I'm worth a negative like $100,000.
I'm like, okay.
You can have half of my debt. Only half of something you're gonna get.
This is the time to get married.
Yeah, exactly. I got nothing.
So what is it? I gotta get married now because if I start making money,
Yeah,
I know.
Just stay in the negative. Oh my gosh, that's too amazing.
I don't see me going into the black anytime soon, so.
Oh, I love it.
it's like an investment. You gotta put your investment
Yeah.
in.
Invest in my future by marrying rich.
Marry me now, but you pay off some of the future. I swear. Just-
That's it. You gotta roll the dice.
You're gonna look at my long-term potential. Don't look at the potential now. Just what's in the long term. But here's a prenup saying anything I get in the future isn't yours anyways.
Oh my gosh, one time I was in court and my cell phone went off and the song on my cell phone, the ringer was
Gold digger by
Gold
Kanye
Digger.
West.
Thank you. I was like, oh God, please don't look at me. It was Gold
But
Digger.
yeah, when I get to do my law firm commercial, I'm using that song. That'll be the end. If you had no
Are
problem.
you on the husband's side at least?
No, it was funny. My client from Liar Liar. Oh, jeez. I'm trying to pull up my PowerPoint. Yes, I have one for myself. Just to keep me on track. But now I can't find it. Oh, there it is. Oh my gosh. Yeah, so I just thought today we would go over chapter 3, the cases and the code sections, and just get your opinions, and then just do the highlights from chapter 1 and 2. Because I heard you guys are writing essays on Saturday, huh?
Yes, I have no intention of being here. So.
Are you gonna be here?
I'm not. I feel a cold coming on.
I'm gonna go myself. I feel like Will has the same.
I don't think Will's gonna come. No.
No, poor Will.
I can't do it this time. I haven't slept all week, and I'm just like, no.
You say tomorrow. Let's go tomorrow.
I can't. I work tomorrow.
It's like 3 business hours.
Yeah. I'm gonna sleep 9 to 5. Now the one day of the week the Kathy's gonna be in the office because court starts. So
Yeah. Oh, that is It's amazing, amazing.
She's been sitting there waiting for a verdict all week, so tomorrow she's finally back in the office on crap.
Oh my God. And then that's when she's like, here, I need this, I need this.
Yeah,
I need that.
exactly.
Yeah. Where's this? What are you doing on that?
Yep.
Yeah, I remember those days. All right. So, sorry, I don't know why this is not pulling up.
So is this what you usually go through and see someone ask for divorce papers?
Yeah, like this morning I had my divorce. Oh, it pulled up. This morning I had my divorce workshop, and so we go. And I don't think I put kids in yours. I give you a break.
I think there was kids.
Was there kids? Did I put kids
Maybe.
in there?
Property declaration. Influence.
Oh, it's already filled out.
Maybe not.
Yeah, I think I was like, you guys don't need to worry about kids. This will be your starter divorce, your first marriage.
First marriage.
When you just have like wicker furniture. TV stand.
Yeah, exactly.
Mattress on the
New
floor.
video games.
No, that's mine. I bought before marriage.
But yeah, so I did a 2-hour workshop this morning. We just go over all those page by page. So I'm not going to do that to you guys. You guys don't deserve that. But yeah, we can do that later. And the only reason I did that was luckily this chapter opened the door for me on page 159 when you're talking about the FL160s. And the FL160s I put in here, and that's just like for disclosure purposes. So you can actually see this inventory they talk about of disclosure of what your things are, and you have to let the judge know what's community and then what's separate. And if you don't list it, then you're not going to get orders on it. So those are good times. But I guess we can start into that first case, that George versus Ransom.
I just had one question about the gift section.
Uh-huh.
So it says on 160 that during marriage, personal gifts made by a third party to both spouses are concurrent separate property. Why isn't it just community property?
I read
And
that.
what's the difference between concurrent, separate, and community?
I read that and I thought there's nothing different because concurrent just means 50,
You own it together, yeah.
Yeah, because you don't own all of it. It's not like this is all my separate. I would still have to divide it with the other person who owns it with me.
Yeah.
So that's the first I've heard of that. It made no sense to me.
Okay, so it's just basically treated as community property?
It's always, yeah. If it's a gift to both of you, it's community property.
Okay.
We just divide it.
All right,
So
yeah, I was reading that, I'm like, that doesn't make sense.
And I think where they kind of get too technical is they're saying the same thing. So if you're like, Your Honor, it's concurrent separate property, they'd be like, what are you talking about? Like, we're
How
going
is that not
to split
community?
it. It's community. You both own it. It's gifted to both of you. We're going to split it.
Okay.
So I did see that. And
Okay.
I questioned that too. I've never heard of that.
Okay.
And it's, in every court I've been in, it's never been treated that way, but I'd love to see someone bring it up.
Okay.
But, and that's the thing, like inheritance too. And inheritance is, if it's inherited by both parties, they just consider it community property and split it.
So, just for
Mhm.
future purpose.
Mhm.
So, like, in a will, if it says, like, I bequeath my estate to my son Vincent and whatever spouse he may have, then it becomes community property. But if they just
Both
say,
inherited it, yeah.
So you gotta suck up to the in-laws.
Uh-huh.
well, no, I care about my parents. I'm not gonna give them that.
Oh,
Unless I'm gonna suck, unless they're rich, then I'll suck up to them. But yeah, because
Uh-huh.
I thought during like wills and trusts it basically says like if it's only left to you, but if you're dead, then it won't go to your spouse because
Right.
it doesn't work that way.
Right.
So it seems like it's a double-edged sword. Like
Uh-huh. Yeah.
you either get it all or it gets split between the two of you.
And from what I've seen with wills and trusts is typically they will just leave it to the family, and then because, you know, God forbid when someone dies, they don't know the state of their marriage whatsoever, and so they just assume like if you're happily married, you'll share it, but if you're not, then it goes to my son, you know.
And could you like list it as a way of like I leave it to Vincent?
Mm-hmm.
If Vincent predeceases, then it will go to whomever his ex-spouse was? Or would that still make it considered community property?
I think that usually what it would do is talk about like if you have any children, like it would leave it to you.
Just leave it to the
issue.
kids.
Yeah.
Then the spouse is
Right.
responsible for it, at least
Sometimes,
if they're minors.
Yeah, sometimes like they could be in charge of the money for them. But then again, from what I understand, and I've never done probate, but from what I understand from my probate friends, is that probate is just as nasty as family law, but with more money. So I think if they have attorneys, usually the attorneys like, look, leave it to your direct line and not the spouses.
Okay.
I mean, you can obviously, but then
because I'm thinking of a way that like if I die, they can get it.
Mm-hmm.
But if we divorce, I don't want it to become community property.
Right. And I think a way that you might do that without even really knowing you did it is that whole like if you put it into a bank account and you give it like a payable on death, like this account will go to my spouse, payable on death, then I think that causes a real issue of, I know they said like you can trace it through inheritance, but then payable on death, said, isn't that almost like leaving it to that person is all theirs? So I think that's where you can walk into that mess, at least walk into some litigation on that.
Yeah, because I was like, I don't want it to become theirs if I don't want it to become theirs.
Well, the idea is you marry someone who you love so much that you don't mind that all of it becomes theirs.
Yeah, well, you know what? Love ends. In at least 50% of the situations.
I just always tell people just have as many accounts as you need and just keep things separate. Like keep it all separate. Like this is my inheritance account. This is my rental property account from my condo before I got married.
Well, when I worked at the bank, I mean, that's how people would do it. I mean, they'd have 13, 14 accounts.
Right.
And they'd give me a card and say, I want to go into this account, I want to go into this account. And I'm like,
they're doing it for a reason.
Yeah,
just to keep the accounting straight and easy. But no, those are great questions. I did read that. I'm like, what are they even talking about? Concurrent separate property interests. So that made no sense to me. I don't think the state of California knows that either.
The author knows something we don't.
Right? Yeah. So, and then ransom, I really think ransom was a pretty easy case, and then we can discuss what you guys think about it, if you think it's a fair rule or not. I had to know. Is that yours, Victor?
Yeah,
oh, okay. And you guys don't have to stand for me if you would rather. It depends however you're comfortable.
Just reflexes, but
I know.
I know.
No, go ahead.
Yeah.
And so this case, we have a wife who, with her separate money, bought a bunch of stocks for, like I said, paying off pretty well. And we have husband acquired some debts, and now he's putting collections, and this creditor is trying to take their stocks or just money from their stocks, arguing that well, the husband, because the stocks have like the husband's permission to be used any way he wishes, even though he has to acknowledge that it's his wife's separate property. So the creditors are trying to say, well, if he has complete control over this stock, even though it's not his, we should be able to credit it. But that's not what the court said. The court said, no, it's very clear that this is her own separate property, even though the husband can manage it, it's not his.
Yeah. And did you guys like that rule? I thought it was pretty.
I thought it was cool. We never really elaborate as to make sure it's not her, like his property.
Right.
It's a lot of effort to.
And I mean, if you look at the date, like 1860, oh my gosh, that was the Civil War. Like, how advanced.
But isn't that
women were property back then, right?
Exactly, right.
No wonder the husband had
I know,
control
like
of
they
it.
can't vote.
It makes a little more sense.
But isn't it an old rule though, that case? Because even now, I thought you said that they can still get to the ex-spouse's separate property as long as they completely, or was it only the ex-spouse's half of the community property?
Yeah.
So they still can't get to the ex-spouse's separate property unless unless it was their intent to go after that too?
Right.
Okay.
And then technically they're not supposed to go after the ex's community property interest.
Unless they deplete the separate and their half of the community.
And then they can try to go after. There are exemptions they can claim to say like, hey, this is mine. This has nothing to do with my spouse. But a lot of times, like if they put a lien on the house, then it's going to be sold. So you could still lose your home essentially if they put it up for auction, but you would get your community interest out of it,
And then
the money out of it.
So say they come after your half. Can you get like because I know you can do like the request for restitution or whatever it is to get stuff or repayment that you've paid out of your separate to get back in the community. Can you get like a judgment against the ex-spouse for the half of the community property that his lender or their lenders took?
You can, but they can also have that discharged in bankruptcy.
Oh, so that's dischargeable?
And at least in family law, if they come out, they take my community property interest, and I tell the judge, they took all my interest, I want my spouse to pay me back that money. And they're like, sure, here's your order. And then he could go and file bankruptcy and wipe out any equalization or reimbursement he owed to me.
So then wait until after they file bankruptcy to get the judgment.
Exactly right. Some people are in such a huge hurry to go get that judgment, and like, you might want to wait until he or she says like, I need to file bankruptcy now, and then get your judgment after.
Okay.
Yeah, and in family law, really, there's not like a statute of limitations, like you have 3 years to come in and get an equalization payment. You can reserve on that issue.
Why isn't there a statute of limitations for most things? Is it because things just come up as they come up, or?
I think they feel like you're still in the discovery phase. So I think they give a lot of credit for the fact that you're going through like a really emotional time. And some people will just totally withdraw and let everything go. And then 3 years later, and I get
unless
this
your
all the
spouse
time.
dies and then you're not going through an emotional time period and you only get 2 years to do it.
Exactly. So it's one of those things. It's just like, I think they let you kind of settle and then come back and revisit issues. Not all issues.
But they make the fraud issues where they don't have the statute, right? You can just bring it whenever.
You have 2 years to prove fraud.
Oh, 2 years?
Once there's a judgment and once you're aware of it, obviously. So it's still kind of a long time to be able to do that. And then I think we were discussing the last time about setting aside defaults, how easy it is in family law. 6 months, like I was lazy. Okay, set aside the default. And it's a very low standard.
Okay.
But yeah, so I guess this case, it was basically the American version, and the civil version was saying that, hey, separate property money should be considered community if it was starting to be paid during the marriage. That was the civil common law one, and the American rule was saying, no, separate is separate. And so I kind of like the American rule. I think it makes more sense, as it's nice to just kind of have that consistency where if it was mine before, it's still mine now. Does anyone have an opinion why that wouldn't be a good idea of keeping separate? I think we're pretty much like all separatists in here.
I'm just really against the whole community property system as a whole. So.
Well, and I think that Victor would probably say, like, if you love your spouse.
No, Victor's like, I just say that to sound good, but in my mind, I'm going, that's not.
Victor's like, try not the lines for Valentine's Day. But I mean, I think what Victor would say is, you might be getting this money coming in, but more than likely you're spending it on your community too. Like, hey, I got it $500 this month. Let's go to Sullivan, let's go shopping. And you're probably spending it on your spouse anyway.
Yeah, no, and I gotta tell my friends to let me read your Valentine's before I send them out to make sure there's no legally binding.
Right, no promises. Love you. Happy Valentine's Day.
Okay, that'll pass.
Right? There's nothing binding there. And then, see, Vincent and I were talking about.
I think I mixed with the cases.
You did.
Yeah, I did.
Rude.
Why'd you let me, dude? You want?
That's okay.
Oh, see? Okay. Well, you took the harder one, right?
Well, he took the shorter one.
Well, they're both easy.
Yeah, they're both pretty easy.
That's why I was like, I didn't cite any cases, but I figured you guys were like, you had it under control. And then Devlin, and let's see, Victor, did you have a feeling about Devlin? Because Vincent and I talked about
I
Devlin.
agreed with it.
See?
Because the guy always says,
Yeah.
he's not handicapped now. It's like,
Right, right.
The wife can still go educate. Don't try to take half his stuff. I thought they made the right call.
She just wants out of the house.
For what? It's a specially designed mobile home for his needs. Like, what's she can do?
But she hasn't worked in years.
But she can work. This guy really, literally can't work anymore.
That sucks to be him. Shouldn't have gotten a car accident.
Well, then is she leaving him because he's in a car accident?
Probably, honestly.
She's breaching her duty of the vows. Are you supposed to have some kind of loyalty through sickness and health?
So you
She
guys
just
are
bailed.
amazing family law attorneys,
No,
right?
should have died, and she should have gotten it all.
Yeah, well.
And a wrongful death proceed instead of a
Okay,
personal injury
we can't
proceed.
go back now, man. I'll pull a plug till it's
So, see, Vincent said I was insensitive because I asked him if he's gone to the movies lately, which apparently when you're in law school you don't have time to do.
That's me.
I'm like, I totally forgot.
She's just rubbing it in. Do you have free time?
Yeah, do you have free time? What is this free time you
I
speak of?
was telling Vincent I saw the movie Upside with
I've heard about it.
Kevin Hart.
Kevin Hart, thank you. Kevin Hart is the caregiver of a quadriplegic, and it was so, I mean, it was funny, but it was sad and depressing. And then I read the case after I saw the movie, I'm like, give it all to him. But I said I'd be kicked off the jury.
It's okay, there's no jury trial.
No, exactly. But I was totally biased reading this case, so I wish I didn't see what I did. Maybe I would have been more objective. But yeah, so Vincent has a different perspective. So I'll
You
let
think she should have gotten
continue.
her half of first round jury?
I don't know if she should have gotten half, but I think she should have gotten something out. She quit her job to take care of the guy. She doesn't have an income, and now she needs to move out of the trailer park, and now somehow afford last security deposit. She hasn't worked in how many ever years?
Why is she leaving though?
Because I'm not going to say why, but
Because it sounds like
In the movie, it still showed that was possible. So.
well, maybe not in this one, but I mean, the way that I look at it is, I don't know if I could stay if my spouse became a quadriplegic. I mean, you become a slave to them.
that's why they put the sickness and health term in the contract to cover this thing. So
Yeah, well, that's not sickness. That's
it is sick. It's sickness, man. Oh, he's sick. You can't work.
at least if they're a vegetable, you can still go out and not feel bad about it. If they're a paraplegic, they're alive and they know what you're doing. I don't know.
Yeah.
I still think because she has nothing. Literally nothing. I mean, I'm sure they were living off of his disability. The house was his. I mean,
That's okay. What are you talking about? She wasn't home.
and then, like I said, if she was just there sitting on her ass and he was out working, she'd get half of it, even though she didn't do anything. So why shouldn't she get half of it for quitting everything? Or not at least half, maybe like a third of it or something
You'd
like
be
that.
hurting this guy who literally can't make any more money if he's a half his stuff.
Well, good. Just put him in a home. It's probably better than a trailer park where he's going to be alone. It's not like he's going to, what is he going to do? Wheel around? He can't even wheel around in his house because he can't move his hands. He's going to have to leave the house anyways.
You want to take half his money. Those other homes ain't free, man.
Well, I'm sure he has Medi-Cal or
You're like meta something.
whatever, Medicaid or Medi-Cal, whatever state he may be in. Oh, they're in California. But he has Medi-Cal.
So it's the taxpayer's problem.
Yeah.
Okay, so you're gonna end up paying for it eventually.
Yeah.
You're gonna find the money.
Well, no, he's dead by now. I mean, this was 1982. If he's a quadriplegic back then, he ain't alive still, I bet.
Care wasn't what it is today.
Because they
Right?
left him alone in his trailer and then no one ever.
Well, I mean, it's too true. He's going to end up in a state-run facility probably anyways. I mean, he lives in a mobile home.
Well, then why divorce him? He was gonna die. He just stuck around and kept everything.
And in the words of the girl that I work with at the bank, it would have been cheaper to keep her.
Exactly.
But
Deal with it for a while.
We had a woman come in and ask for a restraining order because her husband said it's cheaper to keep her, and she thought it was a threat.
No, that's the opposite of a threat. I want you around because it's cheaper to have you around.
And she was screaming and crying that my male paralegal didn't understand. Oh, that was like a target on her head. Or
Did he say it with the menacing accent though?
Probably. I would give you that.
I'm not gonna leave you. It's cheaper to keep you. But I don't know. I just.
Well, and that's a good point, because I think if you go on state assistance, they look at what assets you have and then they take the assets.
Yeah, they're gonna take it. Someone's gonna get it.
Like, we're
Not
paying
him.
for you, but we're keeping your assets.
Because I mean, I understand the whole community property aspect is you shouldn't become the state's problem if you guys get divorced. Here, he's going to become the state's problem regardless. I mean, at least give her some help.
So what you're saying is help him become the state's problem faster so he gets.
He's coming to the state's problem regardless. He lives in a mobile home with no income. He's not going to be able to stay there. He's going to have to sell it regardless. I mean,
is he getting disability? Because mobile homes are like $300 a month. It's not super expensive.
it was a $175,000 home, mobile home with all its retrofit. So I mean, I'm sure he's getting disability because I mean he doesn't have the money anymore to disqualify him from it. But I mean, he's already getting state benefits. I don't know, and he's not going to be able to stay in the home. The home is going to get sold regardless, and he's going to end up somewhere. But I just think they should have given her at least part of it, because he's going to have to sell the home. It's not like he's going to be able to stay there.
Is that speculative or is that actually a thing?
He's quadriplegic.
Don't be ableist, man. That's
Well, he can't do anything. And it's 1982. It's not like they have the advanced technology.
Oh, that's right. There's no internet back then.
There's no internet. There's no blow-powered wheelchairs. I mean, he can't even. I'm sure there's not even electric wheelchairs in 1982. So he can't even Stephen Hawking it around.
Do you think, now this is wild speculation, since we're talking about speculation, but do you think the wife purposely reconciled with him because he was getting that money?
Yeah.
Because, okay, so, they married in 75, then they separated in 77, 2 years later. And then they remained together until 1981, but it said somewhere in here, prior to the time the parties first separated, husband was severely injured. So she knew he was injured, right? Because it was before they separated, rendering him a paraplegic. The personal injury damages totaling at least $175,000 were received by husband sometime after the parties reconciled.
Yeah, I mean, I'm sure.
So you think she's like, forget it, we'll stay together until he
I
gets
feel
the money?
like she looked like a gold digger and the judge kind of saw it, but yeah, you don't get
Yeah.
it.
I don't know.
You know what I mean? We can't need all the facts. We need a picture of what she looks like.
I know.
So we could judge her.
Right.
They live in a trailer park.
Exactly. No, she
But-
reconciled with him after the accident.
I was just wondering, if that had some, because they were saying it's going to be deemed community property if they pursue it during the marriage. It can't be that it just arose during the marriage. They also have to pursue the money during.
But I can't imagine she is that savvy.
Yeah.
Because
And
she
that's
stayed with him
true.
until they bought a house.
She's obviously not.
So it's
sad.
not
That's what
like-
she lost.
He just got, I mean, I don't think she's savvy enough to think, oh, well, if his personal injury proceeds, he's going to get it. So let's all put it into a house. That way it becomes commingled in community. That way I can then divorce him to get half of it.
Right.
I mean, unless and I don't think she can afford an attorney that is that savvy either.
I doubt it. Yeah, I doubt it. I was trying to read it, if they put it, didn't they put it in both their names, the house?
Yeah,
Yeah.
the house was in both of their names.
Yeah.
Because this was right before they had the whole, because it was in joint tenancy, but it was before they had that special joint tenancy.
Right. Oh, yeah, that's right. That's where I saw that, right? So they were saying that the personal injury kind of trumped the special joint tenancy presumption.
Yeah.
So yeah, that's a good point. And then, Victor, what did you think about the whole personal injury awards are community property, but they're awarded to
Yeah,
the injured person as they're separate?
I was gonna argue that.
Is that like-
I'm just making sure I was right.
always good before you start arguing.
Yeah, because it says
But I found the way they worded it was something somewhat confusing.
No, it makes sense. Look at the law. It says it's community property unless they find the court finds a better way to dispose of it.
Mm-hmm.
So they found a better way to dispose of it. This dude, like, oh, take half his stuff. He's already quadriplegic.
Right.
It's gonna be way worse off. They don't want to put that burden on the taxpayer.
Okay, but 780B provides a right of reimbursement for expenses that were paid on behalf of the injured spouse by either the community property or the separate property of the non-injured spouse. She gave up her job. She became a home taker and basically a stay-at-home nurse.
Mm-hmm.
I mean, you get reimbursed for that as a homemaker if you get divorced.
Yeah, but
So why don't you get reimbursed
because this
for
guy
it?
had receipts though. Like it says he was able to trace all his stuff back to his personal injury account.
Yeah, but 780 says that you can get reimbursed from separate property personal injury proceeds.
I think she's didn't present enough evidence to show what her losses were.
But there is no evidence. They didn't give her anything. They gave her like little things. But she was the guy. The furniture in a mobile home. I'm sure she had like a twin bed and a stained couch.
So, don't you think like they could have
What
argued
kind of couch did
if
It's a mobile
What
home.
happened to the couch?
It's a mobile
No,
home.
that's a nice couch if it's over 70,000. That's a nice little couch.
total vivid imagery?
It's a mobile home.
No, but it's a 170,000 mobile home. It's a nice mobile home.
You know,
But it's because it was retrofitted for a paraplegic.
That is a good. That is
a
that's a very good mobile home. It
That's
just
like a
happens
double wide.
to have wheels on it. It's just a big mobile home.
See, I love this because you guys are like, one is the attorney for the husband, one's the attorney for the wife. You're already involved.
It's trying to take money from a homeless lawyer. Quadriplegic guy. Come on.
Yeah, the state's gonna take it from him anyway, so.
So don't you think wife's attorney should have put on evidence like, this is how much his care would have cost the last 2 to 3 years, and then have like an expert witness testify?
Yeah, that's what I'm saying. Well, last class that was all the cases, right? All these just
Like
evidence.
evidence, right? Right.
Should have put your wage on paper, clocked in.
But I feel like the court should do it kind of like, because
You want the court to do your work for you?
well, they do in family law, which is kind of BS for the most part. They're
That is
like,
true. Most of
okay, you've given us all this evidence, but in the interest of justice, we're going to give a lot more.
Do what we want
Yeah.
to do.
But so when it comes to like homemakers, don't the courts on their own make the determination of what their value is to the community property?
Just half.
Yeah.
Mhm.
So how come?
Like, no, I get it. Like her.
I mean, I get it. He was injured. But it just. I feel like it's unfair to her. Like it's a court of equity.
Mhm.
Like yeah, he's injured.
Like where she should have at least received some percentage.
I mean, yeah.
Like maybe.
The
not
problem
50.
is that
Uh-huh.
she's gonna have. He would have to sell the house
Mhm.
in order to pay her any of it. But I feel like the reality of the situation is, dude's not gonna be able to keep the house.
Yeah, and he's gonna have to help care.
He's gonna have to have
24/7.
24-hour care, which insurance isn't gonna pay for. So he's gonna have to sell the house and go
Right.
home anyways.
Right.
Eh,
So we're actually hurting 2 people.
Yeah, I feel like you're hurting 2 people, and the state's the only one that's going to benefit out of all this. Because once
And
he sells the house,
Uh-huh.
Medi-Cal's going to take their share.
And she's gonna go on public assistance.
Yeah, and she's
more than,
going to. Everybody's going on public assistance.
like the
You get public assistance.
But the only one getting a benefit is the state
attorneys.
and the attorneys. And I'm sure the attorneys aren't going to be getting a benefit
Probably
because she
not.
can't pay him anything and he can't pay him anything.
We're still getting paid for this.
What?
We're still getting paid for this.
I don't think they are though, because neither of them have assets.
That's how you want them to sell their trailers so they can get your.
Yeah.
There's ulterior motives here. You don't care about your client at all.
I'm not taking this case
I'm not sure what paying this.
Vincent's gonna pull up in his Mercedes.
Yeah. To this guy's mobile home and say, okay, I'm gonna put this pen in your mouth, sign here. I don't know. I just for a court of equity, it doesn't seem very equitable
Right. Right.
because this all family law is a court of equity.
Yeah, a lot of times I agree. I agree.
I
And
don't know.
then, do you guys want to go over the whole personal injury claims against the other spouse?
Spouse hurt you?
Well, I mean, it's pretty much common sense. I
Right.
mean, if you're claiming injury from another spouse, they obviously don't get half of it.
Right.
Although I thought it was kind of so with the whole pension part. So if they try and kill you, you just automatically get their pension if they have a pension, or do you automatically get your pension?
I thought it was your pension where it said that. So it's the bottom of page 183. The spouse who's the terminator is
his or her.
Yeah, and that's where it gets confusing because it's like, are you saying his and hers? Or his or her?
But would you still be able to claim the community property aspect of their pension if they had one?
Oh yeah.
So you get yours.
You get yours.
But you also get half of theirs?
Exactly right.
Okay.
Yeah.
So the murdering spouse loses.
The murdering spouse loses half of their pension that they're never going to be able to use because they're in jail for the rest of their life. And then you get all of yours.
That's right. And then you don't get any spousal support, obviously. Like you try to kill me, I don't have to pay you spousal support, but they don't talk about that.
But could you get an order for spousal support and then wait until they reach their maximum their maximum age for mandatory distribution and then take from their mandatory distribution?
Oh, I see. The injured spouse?
Yeah.
Yeah, absolutely.
So like you can get a spousal support order.
Yes, you can. It's but the other way around though. The one who tried to kill you will never get spousal support.
Yeah, okay.
Yeah. And I actually had 2 cases like that in private practice. And they're both females, both tried to run their husbands over with one had a Hummer, the other had a Jeep. Yeah, I know, and definitely could do damage. It wasn't like a little Prius and tried to run over with, right? But it all turned.
No.
It all turned on what the DA was like, the evidence and what they were willing to charge him with. So both of them got charged with vandalism. So then we could get.
I was gonna say, but then it's not.
So we could still get spousal support against the guy that we tried to run over with the Hummer.
See, that's BS.
I know. And it's just all depends on what other people are willing to do. Like if the DA's like, I'm not gonna pick it up. It's a waste of my time. Try to move vandalism, then we get spousal support.
See, I would fight so hard against.
I know, you're like, this is not right.
Goes on with you.
Well, it's like she tried to run me off the road. The DA pled it down. It doesn't negotiate from the fact that the bitch tried to kill me. Why do I now have to pay her?
Did you die?
But did you die? No.
That's the basic argument. But did you die?
And and you'll get a lot of this.
But for the money, she's going to be able to afford another Hummer to do it again.
Yeah, you're lucky. And then law enforcement and DAs roll their eyes because they're like, this is family law. We don't want to have them deal with it in family law. We don't want to deal with this stupid stuff. So that's your other dilemma is they don't take it very seriously either, unless you die. Then they'll take it seriously.
So how hard is divorce after your spouse tries to kill you?
It's probably the same, isn't it?
It's probably the same.
Let's cut it off.
Funny enough, sometimes it can be harder to get divorced. And I saw this a lot too, especially within India. Once the spouse goes to prison,
they have no incentive to do anything.
No, and the courts aren't really inclined to be like, okay, let's hold a trial if you can't participate in the trial.
So I thought maybe usually, well,
you would think,
prison,
right? But
off.
we had a few bench officers like, no, I'm not holding a trial so they can participate. Have them appear by phone, and then the prisons are like, we're not doing that. We're not going to bring them in, and we're not going to have them appear by phone. And so it would get continued and continued. I'm sure there are some judges who are fine with going forward without them.
Or it's cheaper to keep it in that point, just keep the commissary full or something.
No.
The one thing I noticed though in those cases that I helped in India is most of the time it had nothing. So it's like,
it's just an easy divorce.
it's just, so if you can't have your day in court, like you can't have a trial, you're not going to get any spousal support because they're in prison. You're not going to get child support because they're in prison, and then there's usually no assets or debts either. But you just get divorced.
We just want to be out of it. I mean, you don't want to keep accumulating things.
Exactly.
I mean, granted, you're past that probably date of separation, but still, it's
Yeah. And so that's usually what happens is someone files a motion just to get a divorce and fight over everything else later, and you get your divorce, and then you never come back. You never come back to fight over the other stuff. So, those are so interesting, huh? Let's see, what else? The one about, the data separation. Did you guys find that interesting about, and see, I lived through the Davis case, which was a nightmare trying to determine the parties' data separation. And so that is on page, in case you're looking for it. What was it? Page 186. Kind of hints at it, 186, and then 188 and 189. But just basically trying to figure out when the parties separate.
Yeah.
And that makes sense. Like, you don't want it to be up to your peers when your separation occurred, right? Like, you're trying to keep them out of your business as much as possible. But there are a lot of kind of nasty trials when people fight over that data separation. It's usually big money, like pension, spousal support. In California, yeah, exactly. In California, if you're married over 10 years, you could receive spousal support potentially forever. If you're married under 10 years, it's just half the length of the marriage. So you're looking at like, okay, I was married 9 years, so I either get 4.5 years, or I'm married 10 years and I could go on potentially forever. So that's why people fight over, in case you're like, who cares when you separated? That's usually why, spousal support or pensions.
So after my buddies get married, I should stop them at like the 9-year mark.
Right.
Hey, so do you still want to be married? About to cross that pole, it's going to be forever.
You're about to cross that threshold.
We had a judge in family law, and they're like, oh, what's your anniversary? He's like, yeah, 10 years. And we're like, oh my God.
I'm sorry.
Yeah, 10 years, we're just like all gasped. How did you let this happen?
I should be so irresponsible.
Do you know, yeah, exactly. Do you know what your retirement is worth?
Half.
$500,000 walking out the door.
Unless they try to kill it.
Right. So you better
So just start pissing them off now.
Start some fights right now. And then, so the evidence, like those are always the best trials though. When you have a trial, you can have a trial just on the data separation. So you just isolate it to that one issue, and it's always so interesting because it's like a soap opera.
Here's the sex tape from 2015,
Yes,
the sex tape from
exactly
2016, the sex tape from 2017. We're just keep on going.
So you start collecting all those Valentine's Day cards.
Yeah.
Make sure they put a date on them, or you put a date on them. And you know what? Now with social media, God, like that's your built-in evidence. You just pull up Facebook, you know. But they are looking for things like you're going on dates, you're doing family trips, family reunions. They say they don't really care what third parties think, but they're gonna talk to witnesses, you know, like, oh yeah, they said they were never so happy as they were that evening of New Year's Eve, that kind of stuff. It's really gossipy, good stuff. So just to tell you about Davis, because that could show up somewhere on a bar exam just because it was such a nightmare. The marriage of Davis, basically the Supreme Court decided to get involved in family law, and they said, your data separation is when you no longer live together. But I think we talked about this a couple weeks ago. A lot of people just couldn't afford to move out, so they were stuck. Like they couldn't ask for spousal support. They couldn't get custody of the kids. They couldn't even file for divorce because they didn't have a data separation yet. So it went back to just what your subjective and objective intent was. When you knew it was over, and a lot of times the dates are different because sometimes people don't express it so clearly when you knew it was over. So then the judges just weigh the evidence. A lot of times if it's pretty close in time, they'll just split the baby. They'll just pick a date in between and say, okay, you both lost something. Or they'll have a full-blown trial on it. which, like I said, can take a long time based on going through everybody's evidence. So those were just the cases. I think it was pretty straightforward. Nothing was too weird that stood out to me. The person, in case we didn't talk about this subject, just the personal injury settlements. So they're taking the community property settlement and treating it as separate property unless it was just so grossly commingled that they couldn't figure out what was the personal injury award and what the couple had beforehand. I would love to have seen a case on that or an example.
That's like if you have like $1 million bank account and you just throw in your $50,000 settlement and it just merges with whatever you have.
I think so. I just still feel like you can always still at least trace that 50,000 unless you're like.
Or if you use it to pay off like your 1.1 million, or not
Right.
pay off, but do a payment on your house,
Right.
and then then it becomes commingled with the community house,
And they can't possibly figure out what portion was the injury, the personal injury settlement. Yeah, I would have loved to see just what it looked like. There's got to be a case on it somewhere. So I'll see if I can find it. And then just the fairness rule is that they have to give the injured party at least one half of the settlement, like at least one half is the injured parties. And then they have that little narrow exception of giving some of that to the other party who was not injured. So that would be an interesting case too, just to see what that
Well,
was.
then I feel like when you're arguing for a personal injury case, you should say, keep in mind, ladies and gentlemen, this guy is married, and this is going to be hard on the marriage, so you should give him twice the reward money in case she takes half.
Right? It's hard on and trust me, I can imagine it's hard on the community too. You know, like not only is he injured, but his family life could seriously suffer. So yeah, I think you could start arguing for more money based on that.
Because wife's going to leave him.
Right, loss of consortium, that kind of stuff.
I guess that's what you see.
So does loss of consortium, is that still separate property? Or no, because it's not a personal
It's not
injury.
his consortium.
Yeah.
That's a good point, because I feel like that's a community kind of injury.
Yeah, that's a community injury. That's not
Right.
a personal one.
And they haven't talked about that. I feel like that's a community injury. So you could probably argue that, is that the wife should be granted at least a portion of that loss of consortium.
Well, usually the wife would bring it on her own behalf. So she, I mean, technically, or whichever injured spouse. So I mean, I just, I feel like if you get your full $180,000 and I get my $20,000, you should get half of my 20 and I don't get none of your 180.
Right. But yeah, that's it, because I can see it argued either way, where both that money should be community if they were both injured by it. But if one is already getting money and this is just kind of like a little bit of a, hey, you get some money too, then it should be separate.
Yeah, and the problem comes too is with a lot of those cases when they get settled, they say, okay, we'll dismiss the loss of consortium claim if you agree to come up on their settlement by this amount, because it's going to be a community pot anyways until it's not.
Right, until you get divorced, right?
Yeah.
And then it's
So I feel like that's also a malpractice type thing, to where if you are a personal injury attorney and you agree to that kind of settlement, I mean, then you're commingling already, which is defeating the whole purpose of bringing the two separate actions.
And you're walking away from money that could potentially just be the separate property of the non-injured spouse and get nothing possibly. Yeah, that's a good one. We'll have to look into that for the personal injury. Just I wonder if we could talk to our personal injury attorney about that. But I'll see if I can find any cases on it regarding that in family law. I just haven't ever seen one.
Yeah, because we deal with that a lot, because we get the loss of consortium claim along with the personal injury action. And then when the case settles, I mean, usually the loss of consortium party doesn't get anything, and all the money goes to the injured party,
right?
or to both of them as a joint, but it's still, you know, the injured parties. It's not a community settlement.
Right. So, and I wonder if people know that when they're coming up with these settlements.
I'm sure the attorneys don't even know
probably
that.
Not. Probably not. And I feel like that should be part of it.
Because we do that a lot.
Right? Yeah. Like, hey, there's this law saying if you get divorced, there's a chance you're not going to get any of this.
Yeah.
So hold that under your loss of consortium claim. Now, does one attorney represent both?
Yeah.
Oh, okay.
And it's usually the same attorney representing both parties. I mean, I'm sure they signed something saying that it's a conflict.
Cover your rear,
yeah. But normally it's the same attorney covering both.
Because you can see now the competing interests in that. Yeah, I'm going to find out about that, if loss of consortium would be, I'm sure it would be considered a separate, it's a community property, separated divorce possibly.
Because I don't know, because the way that the author writes it is the reason that personal injury is separate is because a personal injury is just that, a personal injury. Whereas the loss of consortium claim, I mean, it can be characterized as a personal injury against yourself because you no longer get the benefit of the other spouse.
Exactly.
But if you're not getting the benefit of the other spouse, then that's technically a community claim.
See, and that's how I feel it should be looked at, is the community has suffered, not just one party. The other party's like, I don't care, you know? But I feel like the community suffered because of it. So maybe the court would treat that as like real community property 50-50.
Which I think is unfair.
Yeah, because it's still a personal injury.
Well, I don't get, it's the same wrong, but I don't get half of their settlement, but they're gonna get half of mine.
Exactly.
You can consortium yourself, man.
Yeah, but it's not the same. I can't love myself the way somebody else can love me.
I love it when I hear but. Here it comes.
You're just gonna get a whole bunch of one-liners for your clients in this. Just be like, you can consortium yourself.
It's gonna be in that pleadings, dude.
Yeah, exactly.
You consortium yourself.
That's an affirmative defense to lots of consortium. Consortium yourself.
You're gonna have to attach like exhibits. What do you mean? Okay.
Here's a video showing you how, in case you've forgotten.
Oh my goodness. Too funny. All right. Well, I think we beat chapter 3 to death. What do you think?
There wasn't much to that.
There wasn't much there. So I guess what I was just going to do is kind of go over some highlights of chapter 1 and 2, just because I thought you guys were going to be writing essays this weekend.
Well, we're supposed to be, but yeah.
Well, the whole reason they do that, it's community property until divorce is just to avoid people divorcing their injured spouses and trying to take their money, right?
Oh, that's a good point. I never thought about it that way. Stay for the benefit of the money, huh?
Yeah. Give them incentives to stay, because I mean, I have a family member who's doing that because they have a kid that has like autism. But, but they got a huge settlement for the kid from something, and then they're not sharing the money with any of the other children. They're like, no, it's all going to this kid. If you guys want some of the money, you have to take it. It's like the same with this. If your spouse gets injured, you can't just say jackpot and leave them injured. So
yeah, that's true.
That's probably what I think that they were doing.
Well, I understand the reason that personal injury proceeds are separate property. I think it gets into the problem is when the one spouse, quits everything to take care of them. Because if you quit everything to take care of your kids as a community, then you get the benefit of the community. But if you quit everything to take care of your injured spouse and then decide if you can't do it anymore, you don't get jack.
I know, but I think if you don't do it that way, you're gonna open up the door to like all these people getting married and pushing their spouses downstairs and getting them all.
Yeah, but then they don't get anything because it's a personal injury against another spouse.
No, but like they frame it or something,
Like a solicitation.
It fell. I don't know what happened. It just fell down the 3 flights of stairs.
Honey, could you go get the milk? Right before she just spilled everything on the floor, so we just slipped.
But I think in this book they should have shown an example of where personal injury work was divided 50-50, just so you could see, oh, this is what they're looking
Like
for.
how far commingled does it have to get to
Right.
be too commingled?
Or like, oh, both parties are independently wealthy, so we're gonna, which makes no sense because they need the money, less than the person who only had a trailer park to their name, But if they're looking and saying like, hey, well, wife has $1 million to live off of, husband has $1 million to live off of, and so all this is just gonna go to the injured spouse. But it would be interesting to just see on what event did they give it to the non-injured spouse, the 50%.
I see, I'm curious because it's just like, wow.
Yeah.
I'm thinking of all the horrible ways you can take advantage of
I
this.
know. I'm wondering if this woman had minor children, would that have tipped the scales a little bit in her favor to say well,
I was just saying, now you're leaving. The husband can't take care of the kids. You
Right.
can't get child support because he's never going to work. You can't get spousal support because he's never going to work.
Mhm.
And then you don't get the house either, or any part of the house.
So
Like,
now you're gonna
you and the kids, have fun.
Yeah, on the street. So I wonder if that would have changed. Probably.
I mean, the author gives a whole bunch of hypotheticals, like, what if they had done this, or what if they had done that? But
Is it always
There's no answer.
No answers yet?
yeah, it's just hypotheticals.
It's
not very helpful.
anyway.
Yeah. That's why you just gotta hope they die. Wrongful death proceeds are all yours because they're 6 feet under.
Yeah, it's true.
So spouse gets into injury, just pull the plug. I don't even need to see her condition. Just
Yeah, I was about to say, if they're that injured, just pull the plug. Sorry.
Yeah, I mean, that is something to consider. I mean, not really, I'm gonna pull the plug. But I mean, when you're doing estate planning, and you discuss it with your spouse, is, you can keep me alive forever. But then if you divorce me,
I get to keep
courts
the
are
entire
probably
thing.
gonna
Yeah.
say, I need that money more than you do.
Can we add that to
Uh-huh.
the healthcare directive?
Yeah, then
So
do
long
not
as she doesn't divorce
resuscitate.
you, not to stick around. So if she were to divorce you, you don't put that into.
You could probably have a postnuptial agreement that says that. And you would basically just say in your postnuptial agreement that the personal injury property would be your separate property in the event of a divorce. You could do that.
But then again, if you're in that point where you're gonna get a personal injury proceeds, you're probably in a veggie.
Close to it, yeah.
So you're not gonna be able to do a postnuptial.
No, man, they kind of work in employment contracts in there where she gets to keep stuff so long as that gets to keeps me alive.
And then, as long as I'm on a ventilator.
Should she divorce me while I'm on a ventilator, she gets nothing. Right?
Yeah. You gotta stay.
Alright, you're trapped.
I love it. All right, so I guess we'll just go over chapter 1, and I just took notes. I don't know. I can't plug this in, can I?
Yeah, well, no, but you can email it. Did you email it to yourself?
I can email it to you
I think
guys.
with the inputs, it's
Oh, yeah,
on
yeah.
laptop, right?
If you want to try to figure that out. I was going to use the restroom too. Do you guys want a soda? You want me to grab you a soda?
I'm good, thank you.
Water or anything? No? Okay.
I go to HDMI, a different one, and stuff happens.
I know there's a way to
Yeah, there's one of these is a computer.
no
Try a
signal.
different HDMI. One of them was an actual PC.
No,
Maybe the PC's not on.
it has to be on. TV.
Nope.
It says press until there. It's a blue light.
It was a computer. I'm pretty sure it's just a fancy monitor with a computer in it.
Yeah, it is. There you go.
Yeah. It's not even 4K.
I'm coming inside.
Am I reading my cell phone already?
I just don't know.
This is something weird.
It's one of three.
One of what?
One of three.
3 essays?
No, one of three that I can miss.
Oh, okay, yeah. Just don't show up the last one. It's just, last one at school, just like, oh, all my absences accumulated.
No. I don't have a password.
So stay super safe.
Are you guys okay to work through the break, or did you want a break?
You can work through
I figured you could just always go and use the restroom anyway, too.
it. So I thought I was going to check our essays tomorrow, but is there like a format for writing family law?
Oh, for the cases?
To write an essay?
Oh.
Like a family law format?
I actually put it in my PowerPoint, so I was gonna
It's
show you
2012, like
how I would
everything
do
else.
it.
What's the matter?
She didn't know there was one.
I'm just guessing.
Yeah.
You hacking?
Yep.
You're hacking the system, bro. You're getting in without permission by guessing passwords.
Is this Chambers part?
Yeah, this is. Oh, look that. I got it. Yeah, I guessed it. What? Yeah.
We're still secure here. It's a password for everything.
So if you email it to let's go.
Just click on the SI up there, the SY, and the email should pop up. There's,
Okay, that's
that's the current email.
so if you email it,
I'm sure you can log in first. Let's log into that one.
I assume that it's saved.
Just use size email.
I
And
assume we want to send it to like size personal one.
That's fine. We can. He's a security guy. It's his fault for staying silent.
That's true, I guess. All right.
Getting super easy passwords that are hackable.
You're totally responsible for that.
I guess email it to Sai. Or here, I got nothing to hide in my email.
I'll just say all your personal stuff and see what's up.
I'm like, really? Are you getting that?
Do you not know your email?
No, I do, but I want to make sure that I don't have anything that I'm not supposed to have.
You're like, I have nothing to hide. Oh my god.
Yeah, I'm like, I have nothing to hide. But on the off chance that I would.
What a Russian wife spending.
Oh, yeah.
Oh my god. Russian money Spain. Question: do you have community property in Russia?
No, like Google's so good at blocking spam. Like I haven't gone spam in months, but then I found out there's a national spam folder, and I went into it.
Oh, I know. Isn't it
I was
scary?
like, wow, what's with all these people messaging me?
They're
It's like,
so crazy and
it's like
creepy.
Russian wife stuff. I mean, like it was not even joking. Actual Nigerian people like messaging me.
Oh yeah, like I need money now.
Like, I have a great opportunity for you.
I just need $30,000.
All right, go ahead and email it to me, and then I can get it up here.
Perfect.
What you buy on Amazon, man? Movies.
Coffee. from Grandine
Right.
Toffee.
Oh, I know that guy.
That's a good
The actual
topic.
guy.
Oh, do you know? Like
Yeah, he's local.
the dad or the kids?
It's the kids. They started.
Yeah, the kids started it. Yeah, that's amazing. I get it for one of my friends because I brought them to it when they were out here, and they're like, "Oh my god."
I think we hooked it up with like a big old bag of things, does a bunch of stuff. It's pretty good. But he's opening up new locations all over the place now. It was
I
all
love
over.
it. Like their milkshakes are the best with the toffee pieces in it
I
and
didn't know
stuff.
they had milkshakes. Oh my god.
Yeah, they have milkshakes and they put toffee in them.
No way.
Yeah.
If you have any feelings, they're just gonna fall out. Stupidness.
Okay, I finally found it. So I guess when Barack Obama came down here, he wanted brandy and toffee.
Oh, that's
Oh, really?
That's so cool.
that's a super bragging right there.
Uh-huh.
President wanted my toffee.
Mhm.
I didn't know it was that famous.
Yeah, they have their map in there that shows like everywhere that they've ever shipped to, and it's like all over the place. I don't want these things. Although I probably should have lost them out, but oh well.
So I was gonna get into your email and see if you like it. You gotta close that office window. That's
Oh, I didn't see that was open.
Yeah. But then if they don't have Microsoft Office, you won't be able to use it.
No, they do because they've. I mean, you can still do it with this, but
Oh yeah, that's fine.
and then
Cool. Okay. So this is yeah, it's so fancy. Thank you.
There you
I'm
go.
just making sure I log out now.
So we touch the left and right. Changes.
no.
What are you doing? Yeah.
Wow.
You're going further forward or backwards?
I'm trying to go backwards.
What are you doing?
Awesome, thank you. That's so good. You're so technologically advanced. All right, so, and I emailed this to you guys too, but I just thought, what else would we do during this period of time? So, separate property defined. Can I just do that?
Should work. Imagine it.
Oh, maybe.
Well, you were right the first time. Just
Yeah.
tap it harder. Maybe.
Oh,
Yeah.
okay, sorry. Yeah,
Don't be so gentle.
Yeah, like, boo. So this is just chapter 3, and so I tried to put it all together, and I emailed it to everyone so you can have some notes. Just sometimes the book I found just drones on, and sometimes it's just nice to get to the heart of what the rule is. So separate property defined, Family Code Section 770. A separate property of a married person includes all of the following: all the property owned before marriage, all property acquired by the person after marriage by gift, bequest, divide, or descent, and the rents, issues, and profits of the property described in this section, which is George versus Ransom. See, you guys already know that. Don't be gentle.
Or double tap.
There we go. Okay. Property acquired during marriage by gift. So I don't know if we really went into this in a lot of detail in the earlier chapters, but California Family Code Section 770 defines gift as separate property, but the common law of gifts determines if and when title has transferred. So you guys might remember this in one of your other classes. Sometimes they talk about it in contracts, sometimes. The law requires proof of 3 elements for a valid gratuitous transfer. Those elements are: the donor communicates a present intent to make the gift, the donor delivers the gift to the donee, it should not be done to the donee, and C, the donee accepts the gift. I think autocorrect changed that.
How do you spell donee?
2 E's. Autocorrect's like, it's just done. The donee accepts the gift. So you kind of have to keep those old school rules in mind when you're arguing that someone made a gift. The law of gifts allow a donor to put one or more conditions on the title transfer. This one is like the whole like Indian giver law. So the common law justification for allowing a conditional gift is based on a clear communicated rationale, occurrence or non-occurrence of event. The donor retains a reversionary interest. So that's like what you were saying. It's like, hey, I'm going to give you this gift as long as you do such and such, or you don't do such and such. And you have to make sure the other party knows it's a conditional gift. So that's kind of interesting. So it's not like a final gift if you put conditions on it.
So what we have to do is go to Hallmark with these ideas for legal cards.
That's right.
Yeah.
And you like check off all the conditions you want met to keep the ring. You could do that. That could be like a whole new twist in Hallmark, right?
Like legally binding.
Legally binding Hallmark. And then they went into this in a lot of detail. Appreciation versus rents, issues and profits of separate property. So appreciation or depreciation is defined as a change in the value between the date of purchase and some later point in time. And how you figure out appreciation is pretty easy. Fair market value at sale minus the contract price. You know, what did you pay for it and what can you sell it for now? That's how it's appreciated. At a sale, what was once one asset becomes two assets. It's the property, so like the home, and then the increased value, the appreciation. So a lot of times people would be fighting over the home, is it community or separate? And the appreciation, is it community and is there a community property interest? And Will brought this up a long time ago, maybe a couple weeks ago, about his sister getting married, about the home.
Mm-hmm.
She buys the home now, she puts down the down payment, gets married, and they start paying off the mortgage on the home. That's that appreciation that the spouse could come in and argue about. So he might not have a right to the home, but he might have a right to a portion of that appreciation. And this was the case I was telling them about a couple weeks ago when we talked about it. Moore Marsden. So we'll go over that case in the future. We haven't gone over it yet. But that is when one spouse buys a home before the date of marriage, but during the marriage, community money is used to pay down the mortgage. The case held that when the community pays down the principal, so not the interest, just the principal, the community is not only entitled to reimbursement, but is entitled to a pro tanto partial share of the appreciation of the property from the date of marriage until the time of trial. So what that looks like is just like he was saying, his sister buys a home, it's her separate property. They get married, she's still making the payments out of her paycheck, but now her paycheck is community property. And so the community is paying down that principal. And husband is saying that she took my money and paid down the mortgage. I want an interest in the home, a right to a portion of it. Not 50-50, but something. And so they're going to look at being reimbursed for the payment of the principal. But keep in mind, when you pay down that principal, like I said, your argument would be, yeah, but you were going to pay rent somewhere else. So a lot of times that's a wash. If you help me pay down $1,000, but you would be paying $1,000 in rent, it's a wash, you don't get anything. Where they could get something is that partial share of the appreciation. How much did that home go up in value?
Why is it until time of trial and not until time of separation?
Great point, right? Because, and this is what you'd argue. Attorneys always argue date of separation, date of trial, and then the judge determines which one is fairer. The date of trial, they're basically saying that that home keeps going up and up and up. And so that is the most current number of what that home is worth. Like the closest to trial is the most accurate value of the home. But your argument should be, yeah, but at date of separation, we no longer cared about their interest in the home.
Yeah, because if you separate in 2008,
all that money,
but trial is not until 2012.
Right.
Your house was worth crap in 2008, and now it's back up again.
Exactly. So, attorneys fight over that all the time. So always argue why date of separation is more appropriate. And a lot of judges agree with you. It's like, you know what, at date of separation, you two were done. So what was it worth when you separated? But yeah, according to the case, it's time of trial. And I think the old theory was it's just the most accurate value of the home.
This is only for houses you're still paying off, right? If your house is completely paid off and it appreciates in value while you're married, they don't get half your equity, do they?
Not half of it, but they get a portion of it.
Even if your house is already paid off before marriage?
Oh, no.
Oh, that's
Yeah,
not-
they have to pay part of the principal with community
okay.
profit or community fund before they're entitled to their partial share.
So houses that are already paid off.
They're yours.
They're
They're yours through and through.
Because you're not putting any community interest in it. It's just the ones that have mortgages and it's going up and you're like, I'm part of the reason it went up because you paid down the mortgage.
But I mean, if you use community funds to like renovate the house or something like that, then would they start to be able to get into the appreciation value?
You can. I know we've done that before and it's gotta be like.
Like if you do a reno and it increases the profit by.
Yeah, we put the pool in, it went up 50,000. Exactly.
Sure.
I want reimbursement.
But do you get appreciation or do you get just reimbursement for what you put in?
You would probably argue both.
Okay.
Yeah, because you might say, well, the pool only cost me 10,000, but the appreciation was 60, so I want half of what we put in, and then the portion of what it went up in.
Mm-hmm.
You'd always argue both. But also, when you're trying to figure out date of separation, date of trial, depends what side you're on too.
Yeah.
Because if like the market tanked, time of trial, or
you're like, I want
trial, I want separation. So always just know which one gives you the most money.
It's true.
It is. It's true because your client's like, I'm suing you. Right? So always just look at those numbers, and then how you figure out a lot of this too. Now, more and more people kind of have better access to what their home is worth, like Zillow, Redfin, although I hear those are not that accurate. But you can always, we had to do this for a commercial building. What was it worth in 1982? Like, oh my God. So you hire just someone who's a licensed appraiser to go back and do a study of like commercial businesses on Ramon Road in Cathedral City in 1982. They produce a number. Lawyers and judges don't know really how to argue against it unless there's another expert saying, no, these are the numbers. So you just go back in time and you can always hire an appraiser to give you those numbers, just so you know.
So again, the hypothetical where the house is paid off,
Mm-hmm.
and then you redo your kitchen.
Mm-hmm.
Is half that kitchen community property? And
You could probably argue for a portion of what it appreciated. Like a kitchen usually does bring a lot of appreciation to the home. I could see you could argue both reimbursement and what it appreciated.
Mm-hmm.
If you're using your paycheck to do those things and now you're married.
Mm-hmm.
Most people don't know about this area law, just so you know. So most people don't really think like, I'm gonna go in there and ask for appreciation unless they talk to attorneys.
Oh, don't get really smart now with the internet, right?
Yeah, that's a good point. That's a very good point. So you can always see if you can take out a loan just using your credit information, like the lender's intent, like this is all my loan and I'm putting it all into the home, and then you wouldn't have to worry about a community interest. Yeah, interesting stuff, huh? Okay, and then by contrast, asset income is realizable, severable during ownership. And the income is just the income. So it's basically saying you don't have a right to my income, like you might have a right to my appreciation of a home if you're helping me pay it down. My asset income is just purely mine.
Like rents and stuff, right?
Mm-hmm. Like a condo you had before you got married, you're renting it out, all that money's yours. And it's pretty simple. A house that is rented creates an income stream. The underlying asset produces its own income independent to varying degrees of the owner's labor or daily effort. What that means here, and we're going to get into those cases in the future, Pereira and Van Camp, usually a home, like a rental property, is somewhat of passive income. Now, like my husband goes to the rental property and he'll do like the gardening, he'll write things. That's like the minimum level of effort. But if he's actively working to make a lot of money for our community for a rental property, then a lot of times we could start talking about what their labor's worth, what their efforts were. Like, did he go above and beyond, or was he doing the minimum? And
how was the day he was raking? I mean, it could have been
he's like, I didn't see her raking.
No, you know what? You have to argue that because you don't want to give the paraplegic's wife shit.
So I love, you guys have totally got community property down, because when you're taking the bar exam, just argue both sides. Argue both sides, and you already got that. Like, some courts could do this, some courts could do that. And then that's that case, George versus Ransom. And the issue was the court was asked to decide the scope of husband's legal authority to manage the wife's separate property dividends. Rule rents and profits of separate property continue to be separate property.
So with that, I saw like this little hypothetical on the internet, and it's like I guess husband and wife got married, they moved into the house.
Mm-hmm.
The husband didn't know the house was actually the wife's, and then they were paying rent, and she was just pocketing the money.
Oh my God.
What happens in that situation? It's her own separate. She's taken from the community to her own.
So she's gonna get all of her retirement because I'm about
So she owned the home.
She owned the home.
But she acted like, honey, let's go
Let's rent this place out.
We're gonna rent it.
Yeah, and then she pocketed the rent money.
Oh wow. Well, I think that's her separate property, but where the court's
It's a
gonna get
fraud.
upset. Yeah. Where the court's going to get upset is fraud and lack of disclosure and fiduciary duty. You have a right to tell your spouse these things. So it could come back and bite her, and he might get a windfall and get all that money reimbursed to him.
Yeah,
Isn't that crazy?
Yes.
Wouldn't you be so mad?
I'm pissed.
Yeah. So whenever something doesn't seem right, but you're like, it keeps bringing me back to separate property, you can always argue fraud and a lack of disclosure of fiduciary duty, like the sniff test, so to speak. This is the personal injury claims that we went over in depth. California Family Code Section 780 is a special community property provision. It characterizes as community property money and property received for personal injury cause of action that arose during marriage. It also excludes personal injury settlement from the reach of California Family Code Section. Settlements are subject to the reach of California Family Code Section 2603, a mandatory assignment rule whose purpose at time of divorce is to confirm any money or property received for a personal injury claim that arose during the marriage as the injured spouse's separate property. That is so complicated, and all that is saying is when you get divorced, we're taking that community property and likely giving it to the separate property injured party.
See, I'm just following the law, dude. You don't like it,
Right?
I'm becoming governor.
That's exactly right.
No more community property state. Separate property.
781A confirms a separate property money and property received for a personal injury cause of action that arose before or after the injured person's marriage. So we're just still calling it separate property, but we're doing the same thing. We're giving it to the injured person. So anything you had before you got married, after you separated, separate property. Pretty straightforward. And this is that right of reimbursement. So you guys brought this up, which was so exciting that you guys were thinking about that. 780B provides a right of reimbursement for expenses that were paid on behalf of the injured spouse by either the community or the separate property of the non-injured spouse. So,
Just hit it down at the bottom again. The PowerPoint button next to the gear.
Right there?
Yep.
Okay, perfect. So this is, and can you guys think of some expenses that you would envision having to pay
Yes,
on
being your
behalf?
paraplegic husband's caregiver.
Yeah, there's no receipt, didn't happen.
Where's the contract?
Try doing that for a homemaker raising the kids. Oh, there's no receipt. Shit. Well, like medical costs, like hospital bills, stuff like that.
A ton of them, right?
I mean, if they're not working anymore and you're paying it out of your retirement, then
Right, and then like the making the house retrograde so they had like a ramp and maybe lower cabinets and all that stuff that you would need to do. 780C confirms as the injured spouse's separate property, any property or money received for a personal injury claim brought by one spouse against the other. So that's pretty straightforward. Like, you hit me and this is all my money.
Oh, we get to pay your half.
Was that I hit you? You got the judge. I'm gonna be happy. Mine.
That's all
Well,
right.
that's a really good perfect marriage, and that's how it worked. Like,
No.
Right.
Oh, here's half.
I feel like they really were. Obviously they were concerned about, you know, having to share your money with your abuser, but also maybe like setting people up. You know, like, hey, we're gonna get a lot of money here, and we'll split it. You know, like insurance claims. Yeah, insurance claims. So I don't know. People are weird. Let's see, what is this one? A personal injury cause of action against a third party that arose during the marriage. This is what we were talking about. Must be pursued during marriage in order to produce Section 78 community property. If the injured party does not sue the tortfeasor before a dissolution of petition is filed, then the cause of action is left to the control of the injured spouse. And so basically what that's saying is that you have to pursue that injury during the marriage. Once that petition is filed, you have no community claim to it whatsoever.
So you can't even get reimbursement back. So if they just hold off on filing the claim, but you've paid out for almost 2 years, could you then ask for reimbursement or no? Since according to that,
I think you could, because that's a really good question, because that money was spent during marriage and now the spouse has the funds available to then pay for these things that didn't exist before. So I think you could argue still that that debt was incurred during the marriage and they're responsible for that debt, and money out of your pocket. So I think you could definitely still argue that, absolutely. It wouldn't give you a right to the actual personal injury award, but
you
just
can
kind
say
of
reimbursement.
Right, making that person whole again, so to speak. So I definitely think you could argue for that reimbursement. And 783, the rule is that a third-party tortfeasor cannot raise the contributory negligence of the other, unnamed spouse, as a defense in a personal injury action brought by an injured spouse. The exception is that a third-party tortfeasor can establish a right of contribution when the defendant cross claims against the other spouse. So I feel like this is probably still, and I don't do personal injury, but I feel like this is still kind of has the same end result, where they're basically saying this is not going to be a defense, but I'm still going to get a portion of my money because you contributed to the car accident in some way. So I think it's more all of a financial thing versus having it be a defense to get rid of the claim altogether.
I don't say spouse, but they don't stay married too long after one of these, do they? I don't see this a couple civilly solving their matters in trial in court. And, sticking together.
I don't see I don't see any marriages stay together, but that's just the nature of my work. But personal injury settlements, Family Code Section 780 creates a special community property category that shall be assigned to the injured spouse as separate property at dissolution. And the two exceptions that we've gone on about commingling, and then it's transmuted to community property by operation of law, meaning it's just if they can't figure out whose is whose, it's just going to be automatically community property. And two, fairness, narrow grant of discretion that if exercised mandates an award of at least 1/2 of the settlement to the injured person. So that would be such a great essay question, is what would be fair? Like, what scenario would it be fair to take that personal injury award and divide it in half? I still think children are probably involved in there, or the other party has major medical issues too. It's got to be something like that. Tracing principal and injury settlements. Word damages, this was good too in the case. Word damages is to mean money received or purchases made with the money received. So it's not just money in this case. Family Code Section 2603 effectively supersedes special joint title presumption, although special joint title presumption was not in effect at that time. So, and I think you brought this up, Vincent, and I haven't seen anything rebutting that yet. So I'm assuming, yeah, okay, we're just gonna let it trump the special joint title presumption. Devlin, personal injury damages received or to be received from a cause of action arising during marriage are community property unless the court, taking into account the economic conditions and needs of each party, exercise the discretion of the court and substantial evidence standard. So it just has to be some substantial evidence to deviate from making that personal injury property, community property awarded to the injured spouse. Oh, we already went into this one, but personal injury claims against the other spouse. A personal injury recovery received from a spouse is the injured spouse's separate property. Proximate contributory cause, any money or property received in satisfaction by the injured spouse for the injury is defined as separate property from the date of receipt. Violence, the confirmation of separate property holds no matter when the claim arose, no matter the character of the money used to satisfy the claim, that money is always going to be separate property if there is violence amongst the spouses. Attempted murder or solicitation, spouse retains 100% of retirement or pension benefits. So this is that solicitation, like, hey, I didn't try to kill you, but I talked about it, right?
So those husbands you see on TV where the wife tried to murder them with the hitman.
Yeah.
And then just a little bit of relief, like, I get to keep my pension.
Yeah, you can't touch my pension. Right? And then you wonder, okay, if our minds are going to go there, like, could you set, this would be a great movie, could you kind of encourage your wife to go solicit someone to kill you that was a friend and then set her up so you could keep your pension?
Damn straight.
Right?
If she goes for it, then yeah.
Yeah, exactly. Right? And then you split your pension with your best friend.
Well, she can argue.
Or
right?
a portion of it. That's like a Lifetime movie.
He made me want to kill him.
The Hardin-Manford test. The understanding of a fine line distinction between subjective and objective perceptions of when the parties begin to live separate and apart for purposes of California Family Code 771. So in that case, Davis, the Supreme Court literally took it as live separate and apart. Like, you need to live in different homes. And so family law is like, no, separate and apart just basically means you have moved away from being a couple. You've consciously uncoupled. And that's as apart as we need, that you're no longer in a happy, loving relationship. So now the law is back to you can still live in the same home and be separated. And the clear benefit gives spouses, not third parties, the right to determine the date of their separation. But then again, we give it to a third-party judge to decide, right? Like, yeah, we're still relying on third parties, so. Living in apart. Oh, California, and so you guys, when you're taking exams here and you're taking the bar exam, you don't need to know the family code sections. I mean, if you do, great, but it's not going to be like, what does this code section say? They don't expect any of that. They just want the gist of what the code section says. So Family Code Section 771 confirms that the earnings and accumulations of a spouse after the date of separation of the spouse are the separate property of the spouse. So that's just basically saying after you separate, every dollar you earn is your own dollar, not 50 cents of every dollar. Date of separation marks the point after which the community is unable to acquire earnings and accumulations. Like, there's no more acquiring anything once you have that date of separation. So you can see why people start to fight over it vehemently. No, that mansion was purchased during marriage, not when we were on a break. And by the way, you can be on a break without it being considered a separation. It can just be like a temporary couple weeks, I needed some time. Of course, the other side can jump up and down and say we were separated, but the court's going to look at what happened after Did I come back? Did we make up? Are we still, good? So just breaks are very small. The court usually doesn't consider them if people reconcile.
So we're Ross and Rachel on the break.
I didn't like Rachel, so I'm like, they're on a break, right? She wanted to have it both ways. You've never watched Friends? Wow.
It's on Netflix. It's your homework.
Don't watch Friends. But
I
did you
think
guys?
I'm older now than when
But
I'm
don't
older
you
now
think
than
she just
February.
wanted it both ways?
She
She wanted to be mad, and she wanted him to grovel, and he didn't. Then she was mad and still wanted him to grovel. Yeah. Did you guys ever watch War of the Roses?
Mm.
Oh my gosh. I feel like that should be an assignment instead of reading.
Oh, we could do that.
Like, well, yeah, we'll definitely. And then you can issue.
I have to find it.
Oh. I'm like, are you still talking about watching movies? Because we don't have time to watch.
Well, no, I'm saying I watched my cousin Vinny because I had never watched it until last year.
Oh yeah, that was pretty good.
Or no, I didn't watch it until the second year because we watched part of it in class. So I was like, oh.
Oh, who made you watch it?
Moyer?
Moyer. Yeah, because it was about getting experts qualified.
Oh, okay.
And so it's like, it does actually show you how to more you're an expert.
Right.
And we're like,
Moyer, Marissa Tomei.
And it's actually pretty accurate if the judge like, you don't know what you're talking about.
yeah.
Like they are just merciless. That's all I can say. I remember my first time in court, so I was nervous as it was, and the judge is like, do you want my tentative? I didn't know what a tentative was.
And you're like, no.
That's
How dare you?
It's so serious. It's my first day in court. I'm like, no, Your Honor. And then proceed with my case. And then after I'm arguing, I'm like, you dumbass. Tentative means like, this is what I'm tentatively going to decide, right? But I didn't know that because it was just like on the spot. So then I said, thank you, Your Honor, for not providing your tentative. I really wanted you just to have an open mind. He's like, you didn't know what it meant. So you'll all have those moments. So it just reminds me of the judge and my cousin Vinny. Date of separation means the date a complete and final break in the marital relationship has occurred. Evidence of intent or conduct can be subjective or objective in determining the date of separation. The court shall take into consideration all relevant evidence. Like as mind-numbing as that evidence can be, they have to look at, like I said, love letters, pictures, hotel receipts, that kind of stuff. It's really seedy stuff. And then we're almost done. Does anyone know what time it is?
Yes, right there. It's 7:55.
Oh, okay.
Sounds
Wow.
like TV behind you.
Oh, I didn't see
In
it with
pixelated
this.
form.
Yeah.
Yeah.
I'm like, by the sun?
No. That's unfortunately the temperature outside.
Oh my gosh, I'm keeping you guys really late. I know. But we're not going to take a break, so we're almost done. And this is just like a recap. Chapter 1, Family Code Section 751, the respective interests of each spouse in community property during continuance of the marriage relation are present, existing, and equal interests. So it's what you have right now, it's present, it's existing, so I'm always going to have that 50% right in a divorce or if my spouse dies, and equal is just 50-50. So that's kind of interesting to think about. Like I've already vested, like I already have a right to half of everything we own from day one. So kind of daunting. Family Code Section 720, spouses contract towards each other, obligations of mutual respect, fidelity, and support. And this book really nicely defined fidelity. I remember that was like our first week of class. It was really just kind of like financial fidelity with one another. Like you have a duty to be honest and open about your finances. Family Code Section 1500, the property rights of spouses prescribed by statute, it should be statute, may be altered by a premarital agreement or other marital property agreement. So that is either something you contract before you get married, or you get married and then you contract something after your marriage date. And you can always alter that. And you don't even need to have a premarital agreement or a postmarital agreement, a postnup, if it at the time you're ready to divorce, you guys have a written agreement. You can do all your divorce judgment by written agreement. It could be whatever you wanted. It does not have to be 50-50. Transmutation. So a transmutation of real or personal property is not valid unless made in writing by an express declaration that is made, joined in, consented to, or accepted by the spouse whose interest in the property is adversely affected. So you guys remember this one. This was the case of the Rolls Royce. What was the other thing? Was it there's a Rolls Royce and a home, the grant deed. That's right. So they were found that the grant deed had the required legal language to show that they had they had granted the property interest to their spouse, and the party signed it. The person who is adversely affected signed it saying, here, we're joint tenants. But with the Rolls Royce, remember, there was no signing and it was kind of vague, and so it left it open to, did they really know they were giving away their interest, half of their interest in the Rolls Royce? Transmutation of real property is not effective as to third parties without notice thereof unless recorded. So this is the thing where they want to make sure that both spouses are aware, like you're gifting our property to somebody else. So you have to provide notice or record it with the county recorder so everybody's on notice of that. This section does not apply to a gift between the spouses of clothing, wearing apparel, cheap jewelry, or other tangible articles of a personal nature that is used solely or principally by the spouse to whom the gift is made and that is not substantial in value, taking into account the circumstances of the marriage. So that's kind of like a big catch-all, really. I mean, it's either used solely or principally by the spouse. They have to consider how much money the parties are making. Is this a gift that's substantial in value, or is this chump change to them? I guess really like expensive gifts could be hard to make in divorce court. So always kind of keep that in mind, maybe put it in writing. And let's see, Family Code Section 853, a statement in a will of the character of property is not admissible as evidence of a transmutation of the property in a proceeding commenced before death of the person who made the will. So I had this a lot, where my client would come in and say, well, in our trust, they said that this home is half mine. I'm like, well, that's if the person died. So the will is not a transmutation. The will is saying you, my spouse, and you, my daughter, will be given this home in the event that I die. It's not gifting half of that interest to the wife unless that person dies. So at any point in time, they want to file it for divorce. They're like, I revoke the will, I revoke the trust, and it's still going back to being my separate property. That's not evidence of a transmutation. The Bibb case, the deed was drafted in the statutory form required for expressing an intent to transfer an interest in real property. The deed contained a clear and unambiguous expression of intent to transfer the interest in the property. The DMV printout had no evidence on the face of the document evidencing that the change in form was made, joined in, consented to, or accepted by the spouse whose interest was adversely affected. So that one was pretty straightforward. You guys did an excellent job briefing that one. General rule for term life insurance policies is that the life insurance policy is characterized identically to the funds that purchase the premiums. So if I bought a life insurance policy for my spouse, but I used it all as from my separate property, then the court's likely going to say that life insurance policy is all mine because it came from my separate property. Even though I listed my spouse as the beneficiary, that's not evidence of anything. Obviously, if I die, they get the money, but in a divorce, that life insurance will be mine. But if I use community, then we're going to probably split that life insurance policy if it has any value to it, despite who I listed as a beneficiary. Each spouse has a 1/2 interest in community property policy proceeds, notwithstanding a pay on death beneficiary to someone who is not a spouse. So this is always kind of weird for people to think, like if somebody dies and someone else is listed as a beneficiary, the spouse can still go and ask to have 50% of that life insurance policy given to them from their community property interest. Because remember, they have that 50% interest at all times, even when the spouse dies. This is usually when they have beneficiaries and both husband and wife or spouse and spouse sign off on it and say, I'm okay with this person getting 100% of the life insurance. Typically it's like kids, that kind of thing, where both parties have to sign off on it. In Valley, a transmutation of property is not valid unless made in writing by an express declaration that is made, joined in, consented to, or accepted by a spouse whose interest in the property is adversely affected. So you'll see that over and over and over. Obviously not. There we go. Valley, property acquired during marriage is community unless the preponderance of the evidence establishes that a specifically enumerated statutory exemption applies to make it something else. So this was the case where they were trying to figure out which code section to use. And so they're saying a preponderance of the evidence is what we need in family law, unless there's some other exemption or exception that applies that basically trumps this preponderance of the evidence. And Steinberger, if the gift between spouses consists of a substantial asset, it is not going to be held a gift unless there's a written express declaration transmuting the property from community to separate. So, I mean, think about that. Like if you buy your spouse a car for Christmas, you're going to have to basically write this whole statement. I knowing and intelligently gift to you my community interest in said vehicle and shall be treated as a gift as your sole and separate property.
So it's
Is this not with your husband?
No.
Here you go.
So it just
He
looks,
hates lawyers. I could never get away with that.
it just looks romantic when you put the car on, with the bottle outside. It really is both your car.
Exactly. And you get like you don't have to buy a gift. Like you get a pass. This is your gift, and in reality, we're going to split the equity.
Merry Christmas, honey. I'm now placing us $60,000 in debt.
Yes.
Exactly.
Thanks.
Mm-hmm.
I've always wanted more debt.
And then once you use your income to pay it off, I'm going to ask for half the equity back.
Damn straight.
Yeah.
You know, the car is depreciated.
Right, yeah, yeah. And usually, in case you guys are wondering how the court does that, so let's say they buy the $60,000 Lexus, there's no equity in it. The court usually wants to know, okay, who wants to keep it, who's going to drive it, I'll keep it. If you keep it, you're paying for it. You're not going to split that debt. Yeah, and I think, how I explain it, because sometimes it doesn't seem very fair, is eventually you'll pay it off and then you can sell it or trade it in, do whatever you want with it. I think that's why the court thinks that's fair. And then chapter 2, and then I think we'll be done, guys. And these are just the highlights. I think I only have like 9 pages of notes and then you're done. Chapter 2, Family Code Section 760. Except as otherwise provided by statute, all property, real and personal, wherever situated, acquired by a married person during the marriage while domiciled in the state is community property. So that's like what we learned from the very beginning. California starts here and then kind of works down to the exceptions. So it usually always starts at this is community property, and then you start discussing why it possibly could be separate once you discuss community property. Quasi-community property means all real or personal property wherever situated, acquired before or after the operative date of this code in any of the following ways: by either spouse while domiciled elsewhere, which would have been community property if the spouse who acquired the property had been domiciled in the state at the time of acquisition. So that's just very fancy for this home in this home in Massachusetts we bought would have been community if we bought it in California. So, or in exchange for real or personal property wherever situated, whatever you traded in, if it was gonna be traded in as a community asset in California, we're gonna treat it as like you traded it in Massachusetts for a community asset. So it's basically just saying it's community, but because it's a non-community property state, we're gonna call it quasi-community. Community property ownership rights are not contingent upon a divorce. So like I said, the minute you get married, you have community property rights, and divorce or death. Rather, community property comes into existence at acquisition, whenever you get the asset, which is to say during marriage. When the characters, community, separate property get mixed together in one asset, the asset is said to be commingled. And the act of commingling does not change the character of the contributing property. So some people think, oh, we put separate into community, it's separate property being gifted to the community, so then it's all community. And the courts are gonna say, no, as long as you can trace it, as long as you can figure out what part is community, what part's separate, we'll honor those two different characteristics. It's a lot of work, a lot of math, and sometimes people just say, forget it, it's not worth it. General versus special community property presumption. The general presumption applies to all assets that are not otherwise governed by a more specific and thus superseding community property presumption. The general presumption applies to untitled assets and to, this should be assets, and not asked, assets titled in one spouse's name alone. So general always kicks in if no one's on title or only one person's on title. And why that's fair is usually if there's only one person on title, it usually means they had better credit. And so the court doesn't hold that against the person who didn't have very good credit. Wilson was the case in the record. Some evidence, weak though it may be, which reasonably inferred that the community property funds were used to buy the asset. That was the one where the wife was like, oh, it takes $4,000 to pay our bills every month, and the husband jumped on it and said, see, she said $4,000, we don't have that kind of money. So obviously I was using separate property to pay these bills. So yeah, that was a good case. Fidelity. Fidelity said it was necessary to determine the source of the $1 used in paying the life insurance premium. The burden was on the appellant to prove the $1 premium was paid from community funds. And also the burden was upon her to show that she did not consent to the payment of the premium. So I still don't like that case, because do you know how hard it is to prove that something did not occur? Versus like proving something did occur. It's so hard to prove like you did not say something versus prove that you did say it. But EDIFAR, the standard of proof for rebutting 760 community property presumption is preponderance of the evidence. Just remember, just more likely than not, like 51%, a little teeter-totter is all family law needs. And Lucas, joint title is an affirmative act of specifying a form of ownership and removes it from general property presumption. That's basically affirming, hey, this is both of ours. And so that's basically saying that was almost a gift, letting everybody know, have notice that you both are owners of the property. Only 5 more, guys. Grimius, the character of property as separate or community property is determined at the time of acquisition. So when you buy it, you're going to basically know if it was community or separate. The character of the credit acquisition during the marriage is determined according to the intent of the lender to rely on the separate property of the purchaser or upon community asset. So just remember the lender's intent. Were they looking at both the parties, even though the loan's in my name? Were they asking for my spouse's life insurance policy? Clark, property acquired during the time of marriage, but by way of a compromise of a statutory right, which was in itself property and which was owned prior to the marriage, is separate property. I can't remember which case Clark was. Oh, yes, I do. Clark was the one whose son passed away. And so they were saying that he had a right to that property before he got married to contest the will. I think it was a will.
Yes.
So because he had that right to do it and that right was given to him before he got married, it's going to be separate property. Even though he got paid the money during marriage, it stemmed from a separate property right. That's right. Downer, all the conveyance of the ranch interest to a former spouse was in the form of a gift, but the evidence would support that it was in whole or in part a ruminatory gift in recognition of spouse's loyal and skilled efforts and for services to his employer, thus making the ranch interest and proceeds of its sale community property. So even though it looked like a gift and they thought it was a gift, they felt the gift was based upon the labor of the spouse while he was married to the ex, and thus made it community.
I don't like that. I like it was because you didn't disclose it.
See, I totally
I like
agree
it for
with
that
you.
reason. I don't like it for this reason.
But
I
he had a
totally agree with
stroke and was disabled, and he was going to lose everything. How can you want to take half of it from him?
It was gonna
Well, that's a
cost
different case, man.
How can you want to take half of it from? He's not the state's burden.
Right. I'm all for, let's just say you didn't disclose it, you lose it.
Oh yeah.
Yeah, I'm totally.
Okay, even in that case, even if he was disabled, it's not compensation. I just follow the law, man. Go legislate if you don't like it.
Right, because there's just no legal responsibility to give that gift of a ranch to someone, you know. So he's like, I like you. You can have the ranch.
Yeah, I want to give my employees property if the exes are going to try to take it.
Exactly right. Just always disclose.
They're getting divorced before I sign it.
Yeah, like hold on.
Wait. Let me get divorced first.
Yeah.
I'll hold it in trust for you. So, but can you?
Yeah.
Can you hold something in trust? No, you can't. Because
That's fraud.
Or it's against public policy against marriage. Right? Say, I'll give you this if you get divorced.
But what if he left it like in a will and just said something like, I leave to my friend?
Oh, that's
Right.
true. Using it dirty.
Right.
Yeah, but then it's via a will. It's not a gift.
Right. But that's what I mean. Like, so instead, if it was a gift or inheritance, if it was based upon the service, don't you think she could still argue that part of it was her community property, even if it was through a will?
I'd say.
I don't know.
In Florida, get lost.
Yeah. Yeah, I think she would still try. Like, hey,
I'm sure
I'm
she would.
entitled to a community property portion of
I
that.
just feel like she should have gotten it, but she got it for the wrong reason. That's.
Yeah. So this was your question, Victor, about like, hey, how are we really supposed to start writing the essays?
Oh, okay.
So in my experience, I like IRAC because again, IRAC basically is getting your mind trained to just be repetitive when you're starting to have a stroke because you're nervous in the bar exam. So you just train your mind to follow the same steps. I still like going this route to start your essay on community property with the following paragraph, for example. So it's always nice to jump in just to what community property is. Just lay it on out to start. And this is just like an idea. Just obviously you don't need to write it word for word, but just basically give the definition. California is a community property state. All property acquired during marriage during the course, I'll fix all these typos. The course of a marriage is presumed to be community property. All property acquired before marriage or after separation is presumed to be separate property. In addition, any property acquired by gift, inheritance, or bequest is presumed separate property. So it's kind of nice to state that rule just to get it out of the way and then start analyzing what your fact pattern is. And then I always say, then just break down the essay asset by asset because they're going to be like, what about the car? What about the home? What about the accounts? Just do them one asset at a
time. Be
time.
like our headers, like car, house.
Oh yeah, whatever you can do to make it easier for the reader to follow. We do that with the judges. Like if you make it simple, you're just kind of guiding them to the answer that you want them to reach. So just make it simple, break it down, easy to read. And it's good for you to kind of organize your thoughts that way too. So just breaking down asset by asset. In order to determine the character of any asset, courts will trace back to the source of funds used to acquire the asset. So basically you're saying, well, let's see, if we're saying it's community, why are we saying it's community? Well, it's purchased during marriage. If we're saying it's separate, where did those funds come from to determine if it was separate? A mere change of form does not change its characterization. So this is saying if I had a separate property car and I traded in that car for a new car and paid it off during marriage because I used my separate property to get a new car, even though I got it during marriage, that money came from separate property. So it's just changing forms. Old separate property car, new separate property car. And when does the marital economic community begin and end? So that's all about your earnings. The marital economic community begins at marriage and ends upon divorce, death of spouse, or separation with an intent to not resume the marital relationship. So that's when your economic community ends. Dividing the asset. At divorce, the community assets will be equally divided in kind, unless some special rule requires deviation from the equal division requirement. That's the personal injury settlement. So sometimes they'll sneak that in there because you so want to just divide that settlement. It was acquired during marriage. So also bring up those exceptions, commingled, and anything that's fair. The 3 types of property acquired during marriage is spouse's separate property. And you're just gonna like go over this in detail. Property received by gift or inheritance, rents, issues, and profits of separate property acquired before marriage, and property acquired in exchange for separate property. All right, so that's it, guys. That was all I had to share, just a kind of refresher for you. Log out, right?
Okay, there I go.
Okay. I'll let you do that so I don't come across those Russian brides.
Oh,
Oh my
don't make fun of
goodness.
Svetlana.
Svetlana. So you guys do not have to do your own divorce. We can save that for Will. Poor Will. I hope he's okay.
I'm sure.
We should get sample prenups instead. I think.
Oh yeah, we're gonna do that too. I was gonna have you
Sample
guys,
prenups.
I'm gonna have you draft your own prenup. Isn't that so fun? These are too much fun. And then next week will be Valentine's Day, so I will be here with candy. My husband's so funny. He's like, "What? You're working on Valentine's Day?" I'm like, "So are you." I was like, "Oh." He didn't even check his schedule.
He's like, I wasn't going to.
Right? I'm like, yeah.
He's like, I was gonna quit doing romantic stuff to get.
Yeah, right. That's what he's like, well, now I'm going to work. Nah, this will be perfect. Maybe for Valentine's Day, we'll draft our own prenups.
Super romantic.
Happy Valentine's Day, prenup.
We're gonna get married.
But
Maybe I can find more of the roses. I love that movie. All right. Well, good job, guys. I will see you next week. Oh, yeah, thank you.
Thank you. Alright, I'm not Steve.
Why are you doing this to me, bro?
Because I want people
But yeah, you want myself?
I need sleep. And the lighting department.
Well, that's true. I just remember. Yeah, it's back from here.
See you later.